Hello, class. So we're going to start today on chapter 3. And chapter 3 is going to cover the federal system. So what we're going to understand from today is we're going to trace the roots of the federal system and the Constitution's allocation of government powers. This is how much power is given to either the national government or the state government. As you learned in chapter 2, we've had more than one constitution. So in the beginning of the time as a nation, there was one point where states had all the power, and then over time, national government was given power, and that power has grown, and now national government has more power than the states after the creation of the U.S. Constitution and the evolution of power over time. We're going to determine the impact of some courts. In this chapter, I'm going to talk about court cases, but the uses of those cases are to show how the power between the national government and the state governments change over time. In this course, we will talk about the cases that are very important and many of the cases that are relegated to just understanding how power lies. We'll describe the emergence of dual federalism. We'll explain how cooperative federalism led to the growth of the national government. We'll talk about other types of federalism. We'll talk about how national government and state governments relate to one another. So let me just lay out a brief timeline. Unfortunately, I don't have a handout for this to give you on the portal, but I will make sure you understand how government worked over time before we get started. So in the beginning, in 1776, we haven't really created a government. We had the Declaration of Independence, but there's no real government created under the way that we understand government. And it's not until 1781, 4 years later, that we create the Articles of Confederation, and we now have a government. But remember, the states are the ones who dictate the power under the Articles of Confederation. And so the way that we understand government is not the same way that we understand it today. And so when the U.S. Constitution is created, well, actually, so even before we get to that, so when we're under the Articles of Confederation, we are under a confederation. A confederation is where the states have all the power, and they make up fairly independent units that dictate the policy that goes on within their boundaries, and they operate as kind of like their own little governments. But they band together to do the important things, such as defend the nation. And then they give some limited responsibility to the national government. And again, I'm not saying they're giving power to the national government, because they're not giving, even though the national government could coin money, the states also were coining money. So even the national government could make armies, the states were also making armies. So the states really weren't relying on that government. And so we get to 1787, and it's decided, well, even a little bit prior to that, it's decided that we probably need to put something else in effect, and our legislatures began with defining and creating the U.S. Constitution, which we talked about in Chapter 2. And they dismantle our government under the Articles of Confederation, and they build a government under the United States Constitution, which is going to do one major thing in particular. It's going to grow national government power, because remember, part of the U.S. Constitution says national government is supreme. And that's the supremacy clause. National government is supreme. So there's no subdivision, there's no entity larger or stronger than the national government under the Constitution. And so that's going to flip everything on its head, and it's going to be a huge increase of national government power. Now, it's not going to rip all power away from the states, but it's a huge increase of national government power. Now, we're going to get to a point in the 1830s that the states are going to get a little bit tired of how the national government is operating, and we're going to have new people come into the realm of who the leadership is, and they look at the government a little bit differently. And so there's going to be a time, and we'll go back over this again when we get into the lecture and get into what I'm trying to explain. There's going to be a time where our legislatures and our Supreme Court are going to say, well, we interpret the Constitution differently. We believe that there are two facets of government: the national government, which only handles national government issues and what's stated in the Constitution as powers to the national government, and everything through the 10th Amendment. Remember that whole concept where if the Constitution is silent, all remaining powers belong to the people in the states. They get everything else, which creates two paralleling governmental bodies, And that'll be known as dual federalism. Again, states, a national government has everything that's defined to have. States have everything that they have, plus what is expanded on through the 10th Amendment. And that's how our government will operate until about the 1860s, where the states realized that they can, take back government, or at least attempt to take back government, and reinstitute that confederation, or where the states have all the power and the national government has limited responsibilities. And we see a secession movement in the South, where the states try to indeed do that behavior and become their own nation and put together the Confederate States of America. The name the Confederate States, it's a confederation, under a system that falls within what we had under the Articles of Confederation. Now, we know history. The North wins and the South loses, and traditional federalism comes back into play, where there's a national government, which is supreme to state, and the state creates subdivisions of itself in the local government. And so we see that happen, and dual federalism and the confederation idea is dead. And to prevent from states to doing the same thing that they did, the national government now will absorb a lot more power than they previously had, which will continue to do so up until the 1920s and even until parts of today, through cooperative federalism. So let's get into that's kind of a timeline for you to follow, if you want. And I don't know how well you'll be able to see this. I actually drew it out. So if you want to pause the video, and there's my timeline. I'll try to straighten it up and center it for you. There's the timeline that we're talking about. Again, starting in 1776, and then in 1781, we create the Articles of Confederation. Again, all state power belongs there. It's in 1787, then that's traditional federalism begins. And you see the huge uptick of national government power until we get to the 1830s, and dual federalism is born. And then you're going to see a huge pullback on power by the states until we get to the 1860s, which is the Civil War. We have the outcome of the Civil War, which again will be a huge uptick back into, after that, to the power of the national government, all the way into the 1920s. And we have a fluctuating, state, national government is indeed supreme, but a fluctuating power system between national and state over time, past that point. So let's go. So to understand state power, we really need to understand the 10th Amendment. A lot of what the 10th Amendment does is it allows for the states to have power. Nowhere in our U.S. Constitution do we find much of what state power is. The only stated powers the only expressed or given powers to the state are that the time, place, and manner for holding elections would be left up to the states, which this is a hugely different context than we were used to under the Articles of Confederation. Articles of Confederation, if you looked at it would say state power, state power, state power, state power, and a little bit of national government responsibility. The U.S. Constitution, if you read it, it's national government power, national government power, national government power, national government power. A tiny sentence about state power, and then the rights of the people don't even come in until we amend it or put some appendices on it, which puts in the power, the rights that belong to the people and the rights that belong to the states. And so if you're ever looking for where state power comes from, a lot of it is born out of this 10th Amendment. We might have a different type of nation without the 10th Amendment, because we would be a unitary nation. Unitary would be where national government power reigns across all levels of government, where the national government dictates national, state, and local rules or laws. But we don't have that. We have a binary where we have the national government has powers through the U.S. Constitution, and the states have powers through states' constitutions. And the reason that can exist is through the 10th Amendment. And I will paraphrase it for you. It says, where the Constitution does not give power to the national government, all remaining power belongs to the people and the states. Which is important because there are certain things that exist in our society that are national government responsibility and our state government responsibilities. And then there are actually some things that they both possess an ability to regulate, such as law enforcement. Right now, we have there is a huge disconnect between national government and state government policy when it comes to marijuana, for example. National government has said, well, we want to criminalize the use of marijuana, and that's the national government policy. It's been that way since the 1930s and 1920s, 1930s. But we also have states who have legalized the medical use, and we have that here in Georgia, which is a fairly conservative state when it comes to the matter. But we have it on the CBD level, which is for salves and healing purposes, and we have it on the medical area in some cases of a very few specific, really serious illnesses, and so it can be used for people who have really serious a very particular medical illnesses here in Georgia. But on the national level, that is still illegal. So people who are partaking in CBD and people who are taking in THC, the psychedelic part, to alleviate some sort of medical issue are breaking federal law. But, well, how can that exist? Well, the national government has the ability to enforce law, and the state government has the ability to enforce law, but they don't technically have to do it exactly the same way. And because the national government has a constitution that lays out how they will do things, and the state constitution lays out how they do things. Another area where we see how the 10th Amendment works is law and medical practices. My wife is an attorney. She practices here in the state of Georgia. If she were to, in the state of Georgia, because in the Constitution it doesn't lay out what the standard for the legal practice of law is, it's left up to the state to determine what the legal practice of law is. And so that means that if she wanted to go to another state, she would have to take their test, which is called the bar, to practice law in that state. Now, my wife has been practicing long enough that she will be waived into the vast majority of states that she would want to practice in, or around the nation, because of the way the rules that they've set that up, how they set up law works. So she wouldn't have to take a test anymore because she's been practicing long enough. But in certain instances, she would still have to take the test because law in the state of Georgia may be different than law in the state of Missouri or the state of California or the state of Washington. Medical practices also work the same way. If you're a nurse or a doctor here in the state of Georgia, if you moved, would have to take a board, which is the certifying test that says the medical practices and the requirements of whatever state that you're in, that you move to practice in that state. My best friend's a medical practitioner. He's a doctor. And he lives in Colorado, but he got his medical degree in Tennessee. So he had to take the Colorado board to be certified in Colorado because the medical practices of Colorado are different than the medical practices of Tennessee. And so Colorado wants to ensure that you understand what they require as a medical practitioner, as a doctor, or as a nurse within that state. So if you move from state to state, you have to take their certifying board because the medical practices aren't listed in the U.S. Constitution, so they're left up to the states to define. You see that in many different areas that we talk about when it comes to the 10th Amendment. The 10th Amendment lays out what the state power is. So, I've actually given you this in a better understanding. National government power is, for the most part, expressed in our U.S. Constitution. So let's pull up our handouts. So hopefully you've printed out your handouts for this chapter. And this is probably the best way that I've found to understand national government power, state government power, and the power that they both possess. So on the left, let's start on the left, our national government power. So hopefully you can read my handwriting. But we start with our enumerated powers, the powers that are delegated, expressed, or stated in the Constitution. These are actually the powers that are written down. There are 17 specific powers found in Article 1, Section 8 of the Constitution that actually write out and tell us what the powers of the national government are. Again, powers that the government that belong to the government, which are written down. These are the powers that are expressed to the national government. But that's not the only powers that they can have. We also have what is called the Necessary and Proper Clause, which has a nickname as well, the Elastic Clause. Elastic, if anybody's ever seen like a waistband or like your socks, they can stretch. And so this allows for the expansion, that's where we get the name Elastic Clause, of our stated power. So our Constitution says our government can have an army and a navy. But it doesn't say anything about a National Guard or a Coast Guard or Marines or a currently expanding into existence a Space Force. None of those things exist under the realm of the Constitution. And so we have the expansion on those. So when our army's away, we need somebody to defend our nation. So we have a National Guard. And they're here to keep us safe. When our Navy is away, we need somebody to protect the borders, the waters of the United States and its coasts. And so we have the Coast Guard. Our enemies have amphibious assault teams that can create beachheads and foundations to any type of invasion or any type of strategy that we put out in the world. And so the Marines. And, there's an area of space that exists outside of the United States we call space or outer space that will probably one day need to be patrolled by people to prevent misdoings by other people. And so into existence we're creating the Space Force. So that's an expansion on something that exists. Our Constitution says you can have an Army and a Navy. Well, we've expanded on those, not through amendment, not through through legislation, yes, but we've not through amendment, but we've expanded on those already existing areas to other areas of our nation or our need based on the necessary and proper clause. And what's created out of those, some political science math here, so your enumerated powers plus your necessary and proper clause creates implied powers, powers that can be implied from the use of the necessary and proper clause are our implied powers. So, now again, I'm using the military as this example. It's not as cut and dry as I'm making it. But again, the expansion of our military beyond the Army and Navy could be argued as implied powers. Powers derived from the use of the express powers and the necessary and proper clause. That's national government power. So let's go to the right side of our column. Our state government power. State government power is derived from the 10th Amendment. Again, where the Constitution is silent or does not give power to the national government, all remaining power belongs to the people in the state. Again, where the Constitution is not giving power to the national government, all the remaining power belongs to the people and the states, it's big because without this, we wouldn't have state constitutions. Without this, we wouldn't have states laws. Without this, we wouldn't have states' rights. Without this, we wouldn't have a lot of the rights that you and I, or a lot of the understanding of everyday law that you and I have, because the vast majority of the things that we are affected by are on the state level. And then we have the concurrent powers, the powers that both the national government and state government possess. Again, we're not talking about share. If you have a job, and I go to my job, and this is my job, but if I go to my job and when I get my paycheck, I'm going to look on my check and I'm going to be taxed. And I'm going to be taxed by the national government and the state separately. Well, why? Well, they both have power over me as entities that I live under. And so I have to pay taxes to the national government and I have to pay taxes to the state because they both possess that power. If it was all one, that would be lumped in together and that'd be one tax, not two. And so if you live in a state where there's state taxes, you can be taxed by the national government and the states. So let's go back. So our concurrent powers, the ability to tax, the ability of national government to borrow money, the national state government to both borrow money, the ability of both to create courts, charter banks, and spend money for the general welfare. So tax, again, I told you, when I get my paycheck, it's taxed by both the national government and the state. Borrow money. Many entities such as national government and states borrow money from their citizenry. National government borrows money from its citizens more than the states do. States have a tendency to borrow money from other states, but they can also borrow money from their citizens as well. Both can charter banks. We have national banks and we have state banks. Our states have given the ability to private banks to do banking within their nation. So you don't see a lot of state banks anymore, but because we don't have any state currency, so the private banks exist through the permission of the states. So like Bank of America, BB&T, Magnolia State Bank, all of these exist with permission of the county which they reside, which is controlled by the state. And then spend money for the general welfare. Again, the ability to spend money is a power given to both the national government and the states. We do see state programs, we do see national programs that are designed to help the citizenry in certain ways, shapes, and forms. So let's take a look. Some powers are explicitly denied by our Constitution. So we've just laid out all the powers that national and state both have, but there are powers that are also denied as well. So there's certain things that national governments and states can't do. So the federal government is forbade from creating federal titles of nobility. We have titles, representative, senator, president, vice president, speaker, president pro tem. All of these are titles, but there's no nobility factor created to them. So let's use the president. The president is probably the closest one to what this could be. But presidents, we give the title of president, and they keep that title even after they're no longer president. We still call President George Herbert Walker Bush, or George W. Bush president, or President Obama president, President Clinton president, President Trump president. When President Trump's no longer in office, he's still president. But a federal title of nobility would work like this: if President Trump were to pass away in office, his oldest child would not be president of the United States. That's how it works in the nobility factor. There's a hereditary connection between one leader and the next. And so the child, if we lived in a nobility, a monarchy of sorts, when the president would pass away, their oldest child, or however we would set up the line of succession, would be the next president. Well, that's not how our system works, because our Constitution says there are no federal titles of nobility, which means the leadership does not pass from parent to child automatically. Now, we've had presidents who've had their children become president of the United States, John Adams and John Quincy Adams, George Herbert Walker Bush and George W. Bush. So we see it exists, but again, people had to vote for that to happen, not, based on who you're born to, you become president of the United States. National employees may not accept salaries or other gifts from foreign heads of state. This is very important. We don't want corruption in our government. We don't want another government to be able to give money or influence over a president or any other representative. There is a monetary kind of threshold that this exists where somebody can receive a gift, but if it's over a certain amount, that's a problem, or if it's done in a certain way, that's a problem, because we don't want corruption. We don't want somebody to do something because they were gifted something or given something. We want them to make that decision because they're following the will of the American people or following their own belief, rather than because a person in the X country decided to give them money. States are forbade from taking arbitrary or discriminatory action affecting constitutional rights or liberties. Now, we saw this. We've had the women's rights movement. We've had the civil rights movement. We don't want an arbitrary taking of rights by the states. Now, we've seen it happen, and many times the national government has had to step in to make sure that doesn't continue to happen. But again, the Constitution says rights and liberties should not be taken from its citizenry arbitrarily. If a right is taken, there should be a reason. And sometimes those reasons get challenged in the Supreme Court, and it's our federal government's responsibility to let us know if the Constitution allows that taking of a right or not. You and I, as citizens, kind of decide that. We decide who our leadership is going to be, and how they are going to make that decision. And so we put those people in play to make decisions for us. And that's where we go from there. Both the state government and federal government are forbade from creating a bill of attainder. I think on your notes it says bill or attainder. It's a typo. Bill of attainder, that's a law declaring an act illegal without a judicial trial. So say I was walking down the street chewing bubble gum, and in the city that I live, there's an ordinance that says anybody caught spitting their bubble gum out on the sidewalk automatically goes to jail for 6 months. So I'm walking down the street and I go to spit my bubble gum in the grass, which is perfectly legal. And so I go, but instead of it, making it to the grass, it dribbles out of my mouth and hits the concrete. And at that time, an officer is passing me on the in his car and sees me spit that gum out on the sidewalk, and his flashers go up, woo! And he jumps out of the car and arrests me and says, "You're going to jail automatically for 6 months." Well, that's against the Constitution. The Constitution says, especially through the 14th Amendment, the 5th and the 14th Amendment, that we need to have some sort of judicial hearing before our rights are taken. And so bills of attainder where you're punished for an action just because you did it are unconstitutional. There needs to be some sort of hearing or trial that has determined that you are guilty or of an act before you can start serving time for that action. Now, there is an exception. Dangerous people can be held if they have done something of the level that we've determined to be excessive. And so we have people who stay in jail until their trials are heard, because again, we might fear that they might continue to do those things while we're holding them while their trial is being heard, or they might flee. So we do have ability to do that, but usually if you're found guilty, you're given credit for that time. And again, if you're found innocent, I don't know if we've had a proper recourse. I guess people have sued monetarily for those instances where they've had to stay in jail, but we don't really have an adequate recourse or a way to give back for that. So unfortunately, federal and state government are also forbade from creating ex post facto laws. Ex post facto law is punishing somebody for a crime that was legal. I'm gonna make sure you hear me say it. That was legal at the time it was done. So say so I'm recording this video on a Saturday. But say that on Monday, the state of Georgia decides to legalize the use of recreational marijuana. And so you have people in our society that are beginning to smoke it then because it's legalized. And so say the staff and faculty of Georgia Military College, because you can't smoke on Georgia Military College property or any school or college campus that doesn't allow you to do so. Now, some colleges probably have that ability, but can't smoke on Georgia Military College campus. Decides to go across the street, and they're standing across from the school, puff, puff, give, smoking and passing along marijuana from person to person during their break time. And so say during this first week of allowance, the state legislature of Georgia realizes nothing gets done because everybody's high. And then the next Monday they go and they make the law to where you cannot use recreational marijuana anymore. The state of Georgia cannot go back in time through the week that it was legal and see all the people and document all the people who were using marijuana and say, okay, well, we're going to punish you for the use of marijuana during that time because that's an ex post facto law. You can't punish somebody for something that was legal at the time that they did it. So these are some of the things that, even though the Constitution gives the national government and state government all this power, these are some of the things that the Constitution says, well, no, you do not have the power to do. So again, this is why I gave you the breakdown of that chart. So this is a little blurred. It doesn't really come across that well when you blow it up. So that's why I gave you that chart. So our Constitution is an interesting animal because it provides for some changes in how we understand and how things have been understood over time. Our framers were smart enough to know that our government was going to change and society was going to change significantly between the time that they existed and the time where this document was going to be used and to the end of this document, whether it's forever, a certain amount of time or forever. So they've given out some provisions that are to make life as the citizenry easier, and for us not to have as many fights and arguments over how the Constitution would work or how certain things would come into existence and how they could be fought over. So our Constitution provides a means for resolving disputes. One is through the U.S. Constitution. Our U.S. Constitution is the resolves disputes, and our judiciary is the dispute resolvers in our system. But part of the Constitution that helps us with disputes before we ever get to the court system is Article 4, the full faith and credit clause. It provides that each state give full faith and credit to public acts, records, and judicial proceedings of every other state, and in instances, many territories. So my wife and I are married, and because we're married and our marriage is legal here in the state of Georgia, and actually we got married in a U.S. territory, which is not, doesn't even have a stronger policy as a state. My wife and I we went to St. Thomas and we got married, but that's a U.S. territory, and so our marriage in St. Thomas is recognized in all United States, in all states in the United States, plus pretty much every country in the nation. Every country in the world, not every country in the nation, every country in the world. And so because of that, we can't just go out and willy-nilly decide to marry somebody else without dissolving our marriage, because that's a contract between myself and my wife. And she and I are bound to each other by law as one entity through the legal facet of things. And so I can't go to Washington State, even though it's all the way across the country, and decide to marry another woman because that wouldn't be deemed legal. That I have a contract with one person, and I can't enter into a marriage contract with one person without dissolving the marriage contract with another. It's just not possible. And so there are many types of compacts and contracts that exist that operate across state lines. So I'm going to have my wallet up here on the desk. I'm going to show you two compacts that exist in that regard, and one that exists in that regard and one that doesn't. One that exists in that regard is my driver's license. Now, my driver's license is a very interesting document. It is a state compact. It's an agreement between one state and another state to allow me to that I've qualified here in the state of Georgia as a competent driver, whether I made a perfect score or whether I barely made past the test by 1 point. It says I'm competent enough to drive in the state of Georgia, and all 50 states and many countries have said, well, because he's competent to drive, and here he's also competent to drive where we are. And so this is really nice because then we don't have to stop. I don't have to, if I'm going to, say I'm going to Michigan, I don't have to stop in Tennessee, and then I don't have to stop in, Kentucky, and then I don't have to stop in Ohio, and then I don't have to stop in Michigan to get new driver's licenses for every state to operate a motor vehicle. So it's very convenient, and that and it helps us with societal roles and getting things done. It creates some ease. Now, also a license that I have is I have a Georgia weapons permit. It's got my address on it, so I'm going to cover that up. But the Georgia weapons permit, this one's expired. I got my other one. But this allows for me to carry a firearm if I want to here in the state of Georgia. This is actually perfect for this demonstration, and so that's one of the reasons why I got it. But it allows us to carry a firearm here in the state of Georgia. Now, if I go to other states, that means in some states I can carry a firearm, but in other states they don't recognize it. So not all interstate compacts or interstate agreements fall under full faith and credit. So driver's licenses do, but firearms permits don't. Some states say, we know what, we don't want anybody to carry concealed or even open, and so you can't do so. And then some states say, well, yeah, we trust that you vet your people and you do a background check, and so you can carry in our state. And so the vast majority of states that touch Georgia, recognize that document, and some states don't. And so it's just up to the state. So a lot of this comes from what's built into the full faith and credit clause, which is the privileges and immunities clause. Part of Article 4 of the Constitution, which guarantees the citizens of each state are afforded the same rights as citizens of other states. So we got to remember what we have the understanding there. We're guaranteeing that citizens of one state have the same rights as citizens of another state. That is federally. Whether I live in, again, Alaska or Maine or Florida or Hawaii, federally my rights are going to be the same. Now, within your states, because there's separate state constitutions, there may be certain things that you can do in your state that you can't do in another state. Again, if I lived in Colorado, marijuana is legal. If I lived in parts of Nevada, prostitution in some parts of Nevada is legal. That's up to the state to determine the legality of those things. But federally, the rules that we're all governed by are the same. Now, there are some powers through this same article that are given to the states. One in particular is the extradition law. We want to make sure that people aren't able, as the national government, to do a crime in one state and then run to another state and be safe. We don't want that to happen, because then everybody would commit crimes in one state. So I would commit all my crimes here in Georgia, say, and then go to Florida and live in Florida and be safe because I live in Florida. Well, no, our Constitution doesn't allow for that. Also, under the full faith and credit clause, the action violations that you've done can be punished by the state which you did them, and they can come after you and ask the state that you're currently in to send you back to stand trial for that action. That's called extradition. Extradition. Again, extradition. Extradition. That says that a state must return you to the state where you are accused or you have committed a crime to stand trial. And the state that you're in wants that to be done, because they don't want somebody committing a crime in their state and then fleeing to another state and not being able to be punished, or at least held in a trial to determine somebody's guilt or innocence for that action. And so states are going to honor the rules that they've set in place in that regard. So those are some of the things that we're going to see to make sure the laws of states and the laws of national government are carried out. Again, I talked about state compacts, state boundaries. A lot of people think that, if you commit a crime in one state, so say I used to work at Six Flags over Georgia in my earlier part of my life, and I worked in security, and we used to do all at the end of the night. We'd do money runs where we go pick up all the money at different locations and turn it into the Six Flags bank to be counted and then sent to the bank. So say somebody were to rob the Six Flags bank, and they were on I-20 heading west towards Alabama. Many people think if you're being chased by the police because the police of Georgia only reside in the police of Georgia, that they're not going to be able to follow into Alabama. Well, that's not necessarily true. The police from Georgia are going to follow you. They're going to hit the Alabama line. And before they even get to the Alabama line, they're going to call the police of Alabama to be ready for your run into Alabama. And if you make it into the state of Alabama, what's going to happen is the Alabama police are going to be following you, and right behind them are going to be the Georgia police. And eventually you're going to run out of gas, because that's what cars do. Cars don't run forever. So you run out of gas, they pull you out of the car, they stick you on the pavement, they arrest you, and you're going to do time for fleeing in the state of Alabama, and then in trying to obstructing justice and fleeing from the police. And as soon as you think you're going to get out of jail in Alabama or prison in Alabama, they're going to send you to Georgia to do your time for the armed robbery and the evasion of police in Georgia. So you're going to have to do your time there. It's not the same crime. And so Alabama has a jurisdiction and Georgia has a jurisdiction. Jurisdiction means the legal area in which they can enforce. And so in that legal area which Alabama can enforce, they can enforce and punish you for the fleeing and the obstructing justice, and Georgia can punish you for the armed robbery and the fleeing and obstructing justice in Georgia, because there's two separate jurisdictions. You can be punished separately. Actually, that exists here on the federal level, on the same level, for the same crime. So say I had an armed robbery, and because I crossed state lines, the federal government wanted to get involved. I could theoretically be charged for the armed robbery on the federal level, which is because it's illegal federally, and an armed robbery on the state level, and do time for that same crime under the Constitution, because those two things are enforced separately under the concurrent powers. Now, does that happen? No, not really. Is it a violation of our, the Fifth Amendment, double jeopardy? Well, no, because those are two separate enforcement jurisdictions. Federal and state are two separate enforcement jurisdictions. So that couldn't be done. So now we'll get into how double jeopardy works. Double jeopardy is where the same jurisdiction. So you say you do a crime in Dodge County, Georgia, and you go to prison for that crime. When you get out of prison, they can't charge you for that same exact crime on that same exact day in Dodge County, and then you go back to prison for that. Now that's double jeopardy. During the federal government and the state both charging you for the same crime, that's not, because again, two separate enforcement jurisdictions. Federal is different than state. Again, we live under a system where national and state both have jurisdiction. Again, the ability to regulate law in an area. That's born out of the national government through the U.S. Constitution, which regulates all the land within its jurisdiction. And then we have the state constitutions, which also regulate all the land within their jurisdiction. So the federal government can regulate the whole United States and its territories. The states can regulate all of their territories. So let's get into the cases. So when we're talking about the cases, one, it gives me the ability to tell stories, which I like to do. And two, it gives us an ability to kind of understand how the foundation of the nation and the nation's power works. So McCulloch versus Maryland, a very important case. But again, the idea is when you're looking at these cases, we want to understand what does the main idea of this case mean. A lot of our major cases, I will kind of take a little bit extra time with, and this one I'll take a little bit of extra time with. But I'll give you the answer to the end of this. Is this case is talking about and reinforcing the supremacy clause that national law is supreme to state. So McCulloch versus Maryland, major Supreme Court decision that defined the relationship between the national government and the state. The U.S. Constitution, when it was written and put into play, and it was created in 1787, then put into place in 1789. So it's only like 30 years old at this time, and people really aren't there yet in the application, or still having arguments over what is supreme, national government or state. Many people lived under a life where state government was supreme, and now we have a document that's reorganizing the nation and saying national government is supreme. And so in 1816, Congress creates the Second Bank of the United States. They place that bank in the state of Maryland. So there's one question we want to ask. Does Congress have the power to create a bank? And the answer to that question is yes. Through the concurrent powers, Congress has the ability to create a bank. They can establish banks. The state of Maryland wants to tax that federal entity because it resides in Maryland. And so we have to ask ourselves a question. Does Maryland have the power to tax entities within their state? And the answer to that question is also yes. Through the concurrent powers, states can tax entities. Again, I live in the state of Georgia. The state of Georgia can tax me on my wages if they choose to do so. So the question is, can the state of Maryland tax a bank that belongs to the federal government within their jurisdiction? And through the logic of how we understand the concurrent powers, you would think the answer was yes, but the answer is actually no. And the reason is no is because the supremacy clause of the United States says so. If somebody has the ability to tax you, they have power over you. And to allow the state to tax the federal government would actually go in and fly in the face of the federal government and the Constitution and say, well, states have power over the federal government. And the Constitution of the United States says, well, no, that is not so. National government is supreme to state. And because national government is supreme to state, Maryland cannot tax the Second Bank of the United States, even though it resides in their territory. Again, unanimous decision by the Supreme Court. This actually reinforces the national government's power over states, and it's on that climb up the rung, toward the 1830s, where we get to that plateau in national government power. But this is a growth of national government power. So Givens versus Ogden, 1824. The state of New York gave Robert Fulton exclusive rights to operate steamboats on the Hudson River. However, so this is what it is. The state of New York pretty much gives a monopoly to one individual and his company to operate steamboats on the Hudson River. So if you lived on one side of the Hudson River and you need to get to the other one, and if you can't find a bridge, pretty much the only way to get across in a relatively short amount of time were to pay to use the steamboats. And so for a little short time, Robert Fulton is given complete right to operate steamboats on the Hudson River, which he's got a monopoly. He's been making all the money he can. But Congress decides that they also, to make money, want to license boats to cross the Hudson River, and so they also do so. And so Robert Fulton gets upset, and he goes and complains to the state of New York, and the state of New York sues the United States, saying that the United States does not have the ability to give out these licenses. And so we have the Secretary of State of New York suing the Secretary of State of the United States over these licenses that are being given. And so the argument is, can the state of New York give licenses to a person to operate steamboats on the Hudson River? Well, the answer to that is yes. That property, the Hudson River, resides in New York, so they can give somebody the ability to operate on those waters. The second question is, can the United States government give a license to do the same thing? And the answer to the question is yes. The Hudson River also resides within the United States, and so the federal government can also give such licenses. So this was ruled based on the Commerce Clause. The federal government has the ability to regulate commerce, business, within the confines of the United States. New York is within the confines of the United States, so they can also regulate what happens in the state of New York. So let's take a short break.